Um, Good morning, everyone. I'm Brian Walter, and hold on just a sec here. I got another little technical issue here. Okay, there we go. So, good morning. I'm Brian Walter. I'm a partner in the Liebert Cassidy Whitmore Los Angeles office, and with me this morning, I also have Linda Adler, who's a partner in our San Francisco office, and Jim Smith, who is Senior Resolutions Counsel with United Educators. For Jim, it's the afternoon, I believe.
It is.
You're calling in from Maryland, is that?
That's correct. Good morning, everyone.
All right, well, nice to have you, Jim. And
Glad to be here. Thanks for having me.
Sure. So we're going to talk about getting workplace investigations right. And what we're going to do is Linda and I have a lot of experience not only handling workplace investigations, but advising schools on the aftermath of workplace investigations. And Jim has a lot of experience from the insurer's perspective, the claims perspective of seeing what similar kinds of things, and both working with members on investigations, and then I think more specifically seeing the aftermath of investigations once matters get into litigation. And one of the things that actually Jim and I had discussed before when we were preparing for the workshop today was the fact that what often happens with workplace investigations when you get into an employment lawsuit somewhere down the road is that the actual facts of what happened, was there harassment, was there discrimination, was there retaliation, kind of get pushed to the side, and the focus of the case becomes, was the investigation done properly? So in other words, the school's investigation gets put on trial rather than what supposedly actually happened. And so we're gonna give you tips and insight today on how to avoid that, how to do the investigation right, and so that if your investigation does get put on trial, that it's gonna stand up and it's gonna fare well. There's other reasons for doing investigations too, and Linda will get to that in just a minute. So let's move on to the next slide here. So what we're going to the three basic points that we're going to cover: the purpose and significance of doing an investigation. Why do you do an investigation? When should you do an investigation? And the essentials of conducting the investigation. What are the key procedural steps that you need to follow? And then finally, what are common complaints about how investigations are conducted and communicated? So when Linda or myself, when we're handling a lawsuit or an arbitration and the investigators testifying, what are the kinds of things that are the investigators going to be asked about? And when the head of school is testifying about why the school did something or didn't do something during an investigation, what is the head of school going to say? Or what are you going to say as the business officer or the HR person for the school? So those are all things that are important, and we're gonna go over some examples throughout the presentation today. So with that, I'm going to turn it over to Linda.
All right, thank you, Brian. So why conduct an investigation? Well, usually there's a complainant, for example, asking that the school take some kind of action to stop alleged conduct that they believe is inappropriate. But in order to make a decision to determine what the appropriate action would be, the school needs some kind of factual basis to support that decision. So it's important to investigate to determine what likely did happen, and just as important, to determine what may not have happened. Schools also have a legal obligation to conduct investigations, for example, if the allegation is harassment, discrimination, or retaliation. Also, schools have a contractual obligation to investigate and enforce its conduct expectations set forth in their employee or family handbook or other written policies. And finally, the communities expect their schools to act fairly, and which would be the opposite of acting arbitrarily. So by letting the community know that you conduct investigations to determine, what happened. If there's a reason to believe your conduct expectations may have been violated, it reassures your community that the school acts in a thoughtful, responsible, and fair manner. And it also really models to your community how the school responds and the process that individuals are held accountable for their behavior. And we hope that that would deter future bad behavior.
And Linda, I just want to jump in for a second on the third point, used as a defense in litigation. I can't overemphasize it enough how much having a high quality, timely investigation will help in litigation. I mean, like Brian said at the outset, what we see is sort of a retrial of the investigation happen. It becomes the sole focus of plaintiffs' attorneys. And we hear words like biased, inadequate, untimely, incomplete, inconclusive, inconsistent to describe investigation. It really, then that becomes not the alleged conduct, but it really is the focus of the investigation that a plaintiff's attorney will use to then undermine the decision that was made based on the investigation. So just want to emphasize that point.
Okay, great. So these are the basic building blocks of a fair and thorough investigation. We're going to talk about each one of these, each step separately. So step one is assessing the complaint, evaluating the complaint or the report that the school receives. So when to investigate? Well, I think first it's helpful to recognize when a complaint has been made. And a complaint can be written, but can also be oral, and it can also come from a third party who maybe observed something or has information. So we already discussed that schools can have legal and contractual obligation to conduct the investigation. And yet an investigation doesn't have to be conducted every single time someone raises an allegation. There's some factors that you want to consider when you initially receive a complaint or have information that there might be a need for a complaint. So for example, if it's a minor thing, I don't know, an employee having an attendance problem, showing up to work late, or absenteeism, if there's little room for dispute, something lesser than a formal investigation is probably appropriate. It might be appropriate, for example, just to talk to the employee, and then I think it's always a good idea to document in writing that what happened and what the school's expectations are going forward, but it may not require a full-blown investigation. What's the nature of the allegations? It's really important to look at your employee or family handbook to see if the allegations are true, if it would be a violation of a policy that you have, for example, harassment, discrimination, retaliation, or a violation of your code of conduct, or social media policy, anti-bullying policy. So, and very important to follow whatever process is contained in your handbook, because failing to do so could give rise to a breach of contract claim, and also possibly claims that the school is treating people unfairly with a discriminatory motive. So I would also consider the severity of the allegations. Is this potentially serious misconduct, and what could the consequences be if the school doesn't take action? Is this a first time offense that's being alleged, or is this a pattern? Have there been multiple complaints against the same individual? These are all factors to consider in determining whether to conduct an investigation.
Yeah, and Linda, just on the policies and procedures, again, I want to stress best practices. It's important to have the policies in the first instance if you don't, and to make sure they're reviewed on regularly to fill any gaps, anything that's come to light based on your previous investigations. We just, time and time again, we see those challenges by plaintiffs' attorneys, challenging the fact that you didn't follow your policies and procedures, becoming the main focus in any lawsuit. And you want to make sure that you're not creating workarounds because your policies and procedures are inadequate, because it creates credibility issues when you're doing things on an ad hoc basis as opposed to following the process that's been outlined in your employee handbook. So,
and I'll just add one thing on that. One example of a type of policy that we see sometimes in school handbooks is something like the head of school shall investigate all complaints, and that's an example of there's a couple things that are bad about that. One is what often happens in those situations is someone other than the head of school actually investigates the complaint, and then the employee who feels that they've been harassed or discriminated against or whatever will say, you didn't follow your own policy because the head of school didn't personally do the investigation. Or maybe the head of school did personally do the investigation, but having that in a policy requires then the school to follow it. And so those types of things are those types of steps, investigative steps, are things you want to be really careful about putting into a policy or a school handbook.
And Brian, on that end too, putting in some sort of arbitrary time, you know what I mean? Whether every complaint will be investigated in 15 days or something that's just really unrealistic, or it's silent on the matter. I mean, that's a sort of where I would rely on counsel to help you come up with a time requirement if that's what you're looking for. But that's one of the areas that can be problematic.
Right. It's really important in drafting these policies to incorporate some flexibility for the school, and that it actually aligns with the school's practices, so long as the school's practices are consistent with legal requirements.
Right. Then how do you communicate once you have decided that it is necessary to do an investigation? How do you communicate about the investigation? And I'll just add one other thing on deciding when to do an investigation. I think that can be a tougher call when you're talking about student conduct issues, things like whether two second graders are bullying each other. That can be a tougher call on how you investigate or whether to investigate. When you're talking about some type of complaint of harassment, discrimination, or retaliation in the workplace, under California law, in almost every case, you're going to have an obligation to do some kind of investigation. So when you decide to go ahead and that you need to do an investigation, one of the most important steps is to acknowledge to whoever complained, if there is a complainant, and this isn't something that's being sort of self-initiated, but if there is a complainant, acknowledge to that person that you've received their complaint and that you intend to investigate it. That's all you say. You want to be careful about not over-promising, you simply are letting them know we've gotten your complaint and we're going to do something about it. That's it. This is not a detailed communication. You also want to let them know that they should not be subject to retaliation and provide the name of a person they can contact. This should all be done in writing. You might do it verbally first, but confirm it in writing. This is a frequent source of contention when in litigation about whether or not what the person was told. A lot of times what we hear in employment lawsuits is the employee or former employee saying, when I complained, they told me they weren't going to do anything about it. And so you want that statement, we are going to look into this, to be in writing. And obviously run that by your legal counsel. That's an important document. You also want to let the person who is accused of misconduct know about the investigation. The timing on that may not be the same. There may be a reason that you want to not, particularly in a situation where there's alleged a pattern of harassment or retaliatory behavior by somebody. You may not want to let them know initially that you've started the investigation so that they don't intimidate or taint witnesses or taint the investigation. That's going to be more of a judgment call. And then the other thing that's really important is when somebody complains or somebody is the apparent victim of or possible victim of some type of workplace misconduct, you need to determine what interim steps are necessary while the investigation is going on to protect that person from any further discrimination, harassment, or retaliation. One of the common reactions, sort of intuitive reactions, is, okay, if Jane complains about this, that her supervisor's harassing her, we're just going to move her to a different location so she doesn't have to deal with that person anymore and she can avoid contact with him. It's the right general concept, but it's the wrong approach. And the idea of separating the employee who complained from the person who's accused is definitely something that you should strongly consider, but you should consider moving the person who is accused, not the person who complains, unless that's what they asked for. And there's really no other options. And this is a big point, because a lot of times what we'll hear from schools is, well, they're innocent. The accused, the person who's accused of this misconduct, is innocent until they're proven guilty. And that's sort of, every movie about a criminal trial has that. Everyone knows you're innocent in this country until you're proven guilty. But that's not exactly how these investigations work. And the law is set up, and specifically, there's a number of court cases in California that say it is retaliation as an employer for you to move the victim who complains rather than trying to move the person who is accused. And even on a temporary basis, even though that might seem unfair to the accused, even though maybe you've worked with both of these people for years and the person who's complaining is a constant whiner and the person who's accused is the most upstanding person you've ever met in your life, you still need to look at what can we do to get the accused away from the victim, not what can we do to move the victim away from the accused. And so that's a really important step. Sometimes it involves putting the person who is accused on paid leave, or having them work from home, or having them work at a different location. That can be very difficult if the person accused is the head of school, for example. But you have to look at that. You have to be able to, if there's a lawsuit down the road, be able to come into court and say, we did everything we could to protect the person who complained.
Yeah, and Brian, I want to stress, as far as the interim measures and interim steps that are taken, when a complaint's been filed or over the course of the investigation, it's just incredibly important to document why you're taking those steps, to undermine any challenge to them later. As retaliation lawsuits we see all the time, those can be difficult to defend, especially when you don't have thorough documentation explaining why. Was it at the request of the complainant that you took those steps? Having that, and then checking in periodically with the parties to make sure they understand where you are in the process, that you have checked in with them, and if there's been complaints of retaliation, that you're going to respond to them in a timely way. So just want to emphasize that point.
That's a good point. Okay, so as far as selecting the investigator, this is a difficult issue for schools because you're not like Fortune 500 companies, and you don't have an entire HR department that has an entire division devoted to workplace EEO complaints. And some of the people on this Zoom meeting are the HR person and the business officer and probably 10 other things at your school. And so the resources for schools to conduct investigations are typically pretty limited. And you need to evaluate what type of investigator is going to hold up best given all the various considerations if we end up in a jury trial 3 years down the road. That's a very important consideration. It's also important that your school community have confidence, your employees, your entire community have confidence in the outcome of the investigation, that they don't view it as, oh, well, you had the HR director do the investigation, and we all know how that's going to turn out. So you got to consider that as well. And it's, sometimes when we see certain complaints, we just say to ourselves, okay, this is definitely going to end up in litigation. This is a high risk area. And, and then sometimes we look at the complaint and think, oh, there's nothing here. And I think, Jim, you could probably comment more on this. You never know. You never know. Sometimes the complaints that seem the most frivolous and most weakest end up being the ones that go into a jury trial. You end up in a courtroom or something. So you don't know at the outset necessarily, but you want to look at what are your different options, either external or internal investigator. An external investigator is almost always going to be more defensible from the standpoint of someone who has more training and more experience in conducting workplace investigations. So that's something that it can be an attorney or it can be a licensed private investigator. For workplace investigations, generally, I'm not a fan for an external investigator of using licensed private investigators instead of attorneys. And that's not like some sort of self-promotion. That is simply the fact that most of the licensed private investigators are former police officers, former law enforcement. They tend to be better for other types of investigations that don't involve the legal issues that workplace investigations involve. And so for that reason, if you're going to use an external, my recommendation would be an attorney over a licensed private investigator, although it depends on the situation. There might be times where a PI is sufficient. If you're talking about doing an internal investigation by a school employee, the first thing I would say is if it is a high risk, high profile type of case, it's going to be tough to use an internal investigator. There's a number of factors you want to look at. Does the person have any experience or training doing investigations? Do they have the time to do it in a timely manner? Investigations are very time consuming. They can take weeks or months to interview different witnesses. You have to prepare a report. The report has to contain credibility determinations. I've personally done investigation reports that are 150 pages, and those things, they take months. So you want to consider, do we have the internal resources to actually do this? Maybe it's a complaint that's a very, very, very minor complaint and you think it can be easily resolved internally. That might be a time to use an internal investigator. I tend to think internal investigations in schools are more, there are other situations where it might be more appropriate than a discrimination, harassment, or retaliation complaint. And when we're talking about workplace investigations, that's really the majority of them. That's most of what we see. So let's, and Jim, before I get to the polling slide, did you have any further comments on that?
Yeah, I've seen, just a quick comment, I've seen investigations handled in all manner of ways, both internal and by an external investigator. I think the more complex issues have to be oftentimes dealt with by an external investigator. The more high-level employee, if it's a head of school, for example, the ability to maintain and avoid conflicts of interest with the higher level employees, it's difficult, which would beg sort of going to an external investigator. So it's something to keep in mind. But like I said, I've seen them handled in all manners of ways. I don't think there's any sort of one size fits all. So.
Right. Yes, I definitely agree with that. So let's go to our first polling here, which, let's see here, I got to turn on the polling. So I'm going to launch the polling here. And just to, before I do that, a department chair is accused of age discrimination by a longtime teacher who was just told her contract will not be renewed for next year. The teacher has been a marginal teacher for years, and her performance evaluations have been satisfactory, barely. This was an easy case study to come up with because we've seen this a number of times. So anyway, I'm going to launch the polling now, and let us know, who do you think should conduct the investigation? Business officer, HR director, head of school, outside attorney investigator? Maybe I should have thrown in a fourth option just for the heck of it, but those are probably the three most likely options there, right? And see, I think we have pretty close. We have 90% voted, so there's 6 of you out there that, of course, I don't know if I'm in that group, but well, I think that's enough of a group here. So I'm going to end the polling and share the results. So let's take a look at this and let's see the results, and we'll talk about this a little bit. So we have 51% saying an outside attorney investigator, 42% saying business officer or HR director, and 16% saying head of school. Okay, what I'm going to do, Jim, I'm going to ask you as the claims person with a lot of claims experience, how would you answer this question?
In my opinion, Ryan, I would go with the outside attorney investigator because you're talking about a department chair. So it strikes me that the issues that you could be dealing with rise to the complexity where you could benefit from an outside investigator. That's just my view. I think there's certainly arguments to the contrary, but that's sort of where I'm coming from.
Yeah, I think I agree with that. I would say, as far as using the business officer or HR director, one of the main concerns I would have here is the department chair is the person accused. Very likely at the school, the department chair is at an equivalent level in the school hierarchy or in the school structure to the department chair. The department chair and the business officer, HR director are at equivalent or close to equivalent levels. You don't ever want to have a situation where you have somebody who doesn't have, is in any way, or might even be a lower level than the department chair. Having peers or somebody who's at a lower level conducting an investigation is always dangerous because it opens the investigation up to the fact the person felt pressured to please their supervisors or to please the head of school or to please the board. You have to be careful about that in this type of situation. And the head of school, you don't necessarily have that issue, but you have the issue of training, of time, of resources. And then the other issue for both the business officer and the head of school is how long have they worked with the department chair? Are they friends with the department chair? Have they had the department chair over to their house for drinks or dinner before? Have they ever gone out to dinner with the department chair? Those things would all come up in litigation. And so that's another, and sometimes what we hear is that the culture of the school is important and an outside investigator wouldn't understand it. On the other hand, you can flip that around and say that's exactly why you use an outside investigator, is you get somebody who's neutral, who's unbiased, who isn't caught up in the culture and politics of the school. So I think on that one, I think I'm a little surprised it's only 51% outside investigator. I think this one is a pretty clear situation where you want to use an outside investigator. The one last point I'll make is, it says it's a teacher who has been a marginal teacher for years and her performance evaluations have been barely satisfactory and her contract's not going to be renewed. This is a common situation we see, and it's a high risk situation. There likely could be an age discrimination claim, and the school may not have the documentation to support the reasons for not renewing the contract. So that's another factor there.
That's right.
So the second step that we have then is to gather and evaluate the evidence.
So it's important not to do anything to impair the integrity of the investigation while it's pending. It's important not to discuss any of the facts of the investigation while the investigation is pending, especially because it might later turn out to, the facts might be, and very often are different than what you might think initially, and it could lead to liability for defamation, and it can lead to loss of credibility and really undermine the integrity of the investigation in general, and lead to accusations that the investigation is really just a sham. So it can be hard sometimes because what we see happening often at schools is that the community is aware that there's an investigation going on, right? I mean, people are being interviewed, for example. It could be something that is an issue that's polarizing in the community, and it's hard not to give in to pressure from community members to want to know that is the school doing the right things. It's important to consider in advance what your talking points are going to be to the community to reassure them that you have the proper and fair processes in place and that you follow them, but that you cannot answer their questions about the investigation. It's also helpful to create a confidential investigation binder to keep you organized throughout this process. There's a lot going on with interviews and documents and evidence that you're gathering. So it's helpful to have that in one place. It makes it easier to write the investigation report later if the school is actually conducting the investigation, and it helps to keep the investigation focused. We're going to talk first about the scope of the investigation, and there's a couple aspects to that. You know, at the outset of the investigation, you initially need to determine, you know, which allegations are you going to investigate. I mean, an employee might raise numerous investigations, but it doesn't necessarily mean that you need to formally investigate all of them. A starting point is considering, you know, if these allegations are true, would it be a violation of, for example, your harassment, discrimination, retaliation policy, or some other conduct expectation in your handbook or elsewhere. Another aspect of scope has to do with what kind of determinations is the investigator going to make in the investigation. The investigator should be making factual findings. Now, this is as opposed to drawing legal conclusions. So what is a factual finding? It would be determining, let's say this is an allegation that just came up in another matter that I handled a little while ago. It was alleged that a male employee said to his female coworker, you have a lot of erotic capital. So a factual finding would be, is it more likely than not that this comment was made? That's a factual finding. A legal conclusion would be making the determination, if the statement was made, is it unlawful sexual harassment? And that type of legal conclusion is really for a judge or jury to make in the event of litigation, not the investigator. The investigator should stick to making factual determinations. Did something happen? Is it more likely that something did or did not happen? The school can seek advice from its legal counsel about any legal issues that come up based on those factual findings, but the investigator should not make those determinations. And another thing to keep in mind is that the scope of the investigation, it's often unclear what the full scope of the investigation is at the outset. Sometimes you get a written complaint from the complaining party. Sometimes it's an oral report, but oftentimes it's not until you actually interview the complainant that you really understand the breadth of the allegations. Sometimes the complainant themselves doesn't really recognize the full scope of the allegations until they're interviewed and they discuss everything. So it's necessary oftentimes to expand the scope of the investigation. And we recommend, it's really important that any kind of scope of the investigation be memorialized in writing. So for example, if you have a written complaint, for example, and you start off the investigation based on that, there should be a letter that tells the investigator, look, these are the allegations that we're asking you to investigate. This is how we're asking you to investigate. We want you to make factual findings. We do not want you to make legal conclusions. It's often common in those letters to say, you know, we're going to take your factual findings and review them ourselves and to determine if any of our policies have been violated. And it's important to have that clear instruction to the investigators so they know not to make legal conclusions about, for example, whether or not unlawful discrimination, harassment, or retaliation has actually occurred. And I also want to, in terms of if you have to expand the scope later, that again should be memorialized in another letter that clearly sets forth what allegations are now being added and will also be investigated. And one other thing is that there's a difference between, so you have this investigation, let's say it's an external investigator who's doing the investigation, you get the report afterwards, you learn what the investigator's factual findings are, then it's for the school to decide whether or not its policies have been violated. It's important at that point to review for example, if it's a workplace investigation, your employee handbook, and look at your harassment, discrimination, retaliation policy, look at the standards and make a determination whether or not your policies have been violated. But again, even that is different than reaching a legal conclusion. Many schools' harassment policy, for example, says that conduct does not need to rise to the level of unlawful conduct for it to be a violation of our school policy.
And Linda, just a quick comment. What we see in lawsuits is when the investigator goes beyond the fact-finding or fact-gathering mission into the legal conclusions, we see that being used as evidence of bias because that person's come to a conclusion that's not within the scope of what they're supposed to be doing, and that is then indicative of some bias either against the sort of complainant or respondent in some way. So.
Great, thank you. So the next step is to now interview witnesses, and especially, so if the school is conducting the investigation themselves, I can't emphasize enough how important it is to prepare for the interviews in advance. It's really important to prepare some kind of outline with your interview questions. And preparation is really key to, first of all, being in control of the interview and being able to nimbly respond to situations. For example, the evasive witness that you think is not being truthful, the witness that goes off on tangents, doesn't want to answer questions. It helps you stay focused to have an outline with all of the allegations that you want to ask about, and to have questions designed to get at the who, what, when, where, why, and how of what happened. So you really have a clear picture of what likely did or did not happen. So you should decide in advance as well what type of documents you might want to show witnesses during the interview, emails, texts, and decide what your strategy is and when you want to use those documents. It's common to start off initially asking more open-ended questions and eventually funneling to more specific questions to really get to the who, what, when, where, and why and how. So although it's really important to have the outline, the other advice that I have is that I find it's helpful to have the outline to internalize the issues so that you're able to respond nimbly in the moment. Because what's really important and needed when you're interviewing witnesses is to really listen to what the witness is saying. I mean, you draft an outline and you have a particular order, but that's often not how things unfold when you interview a witness. They could start talking about things that you didn't even anticipate. And it's really important to not be so married to the outline that you can't deviate from it, because it's really important to be able to respond in the moment by asking appropriate follow-up questions. If a witness says something that seems inconsistent to something that they said earlier, or if they say something that just doesn't make sense, it's really important to continue to ask follow-up questions until you feel like you really understood what the witness is telling you and what happened. In terms of the order of what witnesses to interview, it's pretty common to start with the complainant, obviously, because you want to make sure you understand what the scope of their allegations are, and that helps inform your decision about what other witnesses would be relevant to interview. And it's also typical to then go and interview those other possible, percipient or third-party witnesses, and then interview the accused witness last. And the reason for that is because the accused should have the right to respond to all the allegations against them. And until you interview all the other witnesses, you might not know what that is. Does that mean you always have to follow that order? No. I mean, there's times that you need to be flexible, or for various reasons, you may have a different witness order, and it could have to do with witness availability, for example. And sometimes it's necessary simply to just go back to a witness a second time, and even a third time, to ask follow-up questions, depending on information that you learn subsequently. Another issue that comes up is you're frequently asked, let's say you're interviewing the complainant or the accused, they may ask you to interview other witnesses. Oh, you really should talk to this person, you should talk to that person. Sometimes I've seen these lists of, oh, you should talk to these 20 other people. Do you have to interview all those people? The answer is no. I mean, the investigator determines what witnesses may have potential relevant information. So you should ask the person, like, what relevant information do you think this other witness will have? There's not a need to interview 10 witnesses to get the same piece of information if there's no factual dispute, right? But in situations where, let's say it's like a harassment allegation and it's he said, she said, well, now you have a factual dispute. So in that situation, it does make sense to talk to multiple other witnesses to try to resolve that factual dispute.
And Linda, just I want to point out a potential landmine because I've seen this happen time and time again, and I'm sure you have over the course of your investigations, where you're investigating one complaint and then you're interviewing a bunch of witnesses, and those witnesses are also making complaints now, or saying things that should be construed as a complaint, and making sure then those are separately addressed down the road, and they just don't become sort of left there in a vacuum and not responded to. Because we just see sort of this trickle effect or momentum that gets created over the course of investigation. Well, that happened to me too, and things like that. So just have to be mindful of that when you're investigating and you have a widespread investigation. So
that's really important. And one other point I wanted to make is that it's important to also make credibility determinations. I mean, there are times when it's not as much of an issue, but for example, things to look for. Is the witness being evasive? Are they making inconsistent statements? Do they have like a motive to lie? These are all factors to evaluate. It's, you know, I often see situations where schools say, oh, we just can't make a decision. It's he said, she said, that's the end. We don't know what happened. We're not going to be able to figure it out. That's when you really want to look at credibility and determine if you can make a decision based on which witness, you know, has been more truthful and forthcoming. So here's a poll, true, false, or maybe. Parents must be alerted before a student can be interviewed. Is the polling showing, or?
I don't see it.
Well, I'm trying to. I'm working on it here. This is I only have the first question for some reason. I can't seem to get to the next question. Let me see if I can do it this way. Already done that one. Here we go. Okay. Sorry about my technical skills or lack thereof.
I think we almost have everybody in the first one. Okay, so it looks like 62% said it's true that parents must be alerted before a student can be interviewed. Yeah, that's pretty high consensus there. Actually, the answer is false. Parents do not need to be, generally don't need to be notified before a student can be interviewed. And in the context of student misconduct, often the school's best chance of getting reliable information is to speak to the involved students as soon as possible after the alleged incident, before they've had the opportunity to be coached by others, like their parents, and in some cases, the family's attorney. So in other contexts, I think there are some situations where it is appropriate to involve the parents. And the example that I'm thinking of, if you're going to be interviewing particularly young children about sensitive information, like if the allegations have to do with sexual misconduct or abuse of inappropriate conduct towards a child, there I think you have to balance your duty to gather information and conduct an investigation with the duty not to cause, you know, harm, obviously, to the child. So in that situation, sometimes there's discussion with parents and maybe the school counselor about how to go about doing that. But generally speaking, parents do not need to be alerted before a student can be interviewed. Anyone being interviewed has a right, here's the next question, to have his or her attorney present. This comes up a lot. And the polling says 57% of people believe that anyone being interviewed has the right to have his or her attorney present. The answer is maybe, depends on the situation. So, you know, is an attorney going to be spoken to? I mean, is an employee going to be spoken to, for example, about like my earlier example, an attendance problem or something, or some more minor possible conduct violation, no, I don't think you have a right to have an attorney present for every type of interview. If the allegations, if true, could also be criminal conduct though. So for example, if there's an allegation of sexual misconduct and perhaps even egregious sexual harassment, then, you know, I think it is a best practice to allow the individual to bring their attorney to the interview. Otherwise, they could later claim that that they weren't treated fairly. The process was, you know, biased against them, not having the person there. And really, I've seen so many situations where the accused says, I'm just not going to come to the interview. I'm just not going to do it if I can't have my attorney with me. And I think it's important for the school to balance the need to conduct the investigation with trying to get as much relevant information as possible, obviously, including talking to the accused.
And one thing I would add on both of those questions to think about is, oh, there's the, oops. What would that look like to a jury? If you're in a trial 2 years down the road, is a jury going to think that's fair that you told the employee when the employee begged to have their attorney present and you said no? That's a situation where legally maybe you had the right to say no, but from a perception standpoint, that's not going to, the optics of that are not going to look good, not going to look fair to a jury. So at least, especially as the second question, that's one where I feel like pick your battles wisely, and that may not be one where you want to make a big deal about that issue. Okay, so talking about gathering evidence, and I'm just going to cover this very quickly here. You obviously want to look at all relevant documents for an investigation. The one, the two middle ones are what I'm going to focus on: emails, text messages, and particularly text messages and social media. That's where we see a lot of the key evidence in workplace investigations today. And there are some legal issues about the extent to which you can, for example, require an employee to turn over Facebook or other social media information. That's something where if the employee is not going to disclose it, you need to, and you don't already have copies of it, you're going to need to consult with legal counsel because there's privacy rights there. And the extent to which you can compel an employee, for example, to disclose a password to social media is something that's starting to be legally regulated in California. So you want to be careful about that. You may need to look at personnel files or provide the investigator with personnel file or student records. You want to make sure that the investigator has all the information that the investigator needs, and even err to some extent on the side of providing too much information and letting the investigator sort out what is really necessary and what is not for the investigation. Jim, did you have anything to add on that?
Yeah, Brian, it really comes down to also preservation of evidence. You want to make sure you gather and preserve it. If something is lost or destroyed, it just creates the opportunity for a plaintiff's attorney to say, you know, the investigation is tainted in some way, or you have something to hide. And those are things you want to avoid having put in front of a jury. So it's important to preserve evidence.
That is a great point. And one thing that reminds me of another point, which is as soon as you start an investigation or have an idea you're going to start an investigation, you need to stop any automatic deletion of email process that you might have, so that you don't run into a claim later on that you are aware of complaints and you let the email system do its automatic 30-day deletion, or the your cell phone provider or somebody's cell phone provider do an automatic deletion. So you want to be very careful about that. So when you say a legally compliant investigation, what standard does the investigation have to meet? This is a quote right out of the key California Supreme Court case on this issue, the Cotran case, that fairness, investigative fairness means listening to both sides, providing employees a fair opportunity to present their position, and to correct or contradict relevant statements prejudicial to their case. The one point I really want to emphasize on this is if you have a number of different people in an investigation saying things about the accused, you need to confront the person who is accused of harassment or discrimination with that evidence. I see this a fair amount in investigations where the accused is not confronted. The investigator gets statements from 5 different witnesses saying, you know, he harassed her, and they never present that to him, and they never ask him. And then you get to trial or you get to litigation down the road, and that person then has an explanation. As sometimes it seems preposterous they would have an explanation for making these sexually inappropriate comments to all of their female subordinates. People come up with explanations, and the Cotran case and several other cases say you have to ask them for their side of the story, and you have to tell them what the evidence is against them so that they can respond to it. That's a fundamental element of fairness, and that's really important. And so when you're evaluating the evidence, another area that you have to be careful about is the burden of proof. It is not beyond a reasonable doubt. That's the criminal standard. The burden of proof in a civil case and in an employment investigation is going to be preponderance of the evidence. Is it more likely than not that the alleged misconduct occurred or did not occur? This has been a big issue in the college and university setting in the Title IX context, as far as whether the burden of proof should be preponderance or something higher than that, clear and convincing, for example. But for workplace investigations in California, the standard is it more likely than not? Which side is more likely to have occurred? And as Linda said earlier, your investigation has to resolve that question. A investigation report that says, well, he said, she said, and we don't know who's true is utterly worthless. That's not an investigation. That's you know, in football, that's a punt. You need to actually make that decision, and that's one reason to use an outside investigator, is that they're going to have more experience in making those types of credibility assessments. And you need to put your findings in a written report. We've also seen situations where witnesses are interviewed, the school makes up its mind as to what happened and says, okay, well, there's no misconduct, so we don't need to document it any further. No, you do. You need to have a written report for many reasons, including later on, if you ever get sued in an employment case by any employee for any reason, one of the standard questions that you get asked in discovery is, what other complaints of discrimination have you had in the last 5 years, or sometimes longer? And how were they resolved? What did you do to investigate them? So something that's totally unrelated a few years down the road could now make your failure to do a report a critical fact.
Okay, here's our case study. A teacher tells you that the head of school often comments inappropriately about the appearance of women employees. When you interview the head of school, she admits making the comments, is embarrassed, profusely apologizes, and promises to never do it again. So, I mean, what to do now? Should you prepare a written report? Should you take any other action? You know, the way I look at this is, assuming that this is a first-time complaint against the head of school for similar conduct, there's probably no need to do a formal investigation here. This would be an example where there's not a dispute. The head of school immediately admitted to engaging in the conduct and seems to acknowledge that it was inappropriate. The head of school apologized. So it seems like the facts are straightforward and not in dispute. I do think it's important to memorialize what happened in writing, though, in a communication to the head of school. So, for example, a counseling memo that describes what happened and explains what the school's conduct expectations are going forward. And it may also be appropriate, for example, to provide the head of school some coaching with regard to, for example, the policy prohibiting, you know, harassment in the employee handbook, and maybe some sensitivity training. if this is not a first-time complaint, I would view it differently. So if this is part of a pattern, if this is like the third time that someone has said this, then that warrants, that may warrant an investigation. And if the school determines that its conduct expectations have been violated, it could warrant a higher level of corrective action. Because, and we'll talk about it in a minute, but you know, the action that a school takes in response to a violation of its conduct expectations has to be in proportion to the conduct to deter it from happening again. So step 3 is communicating the decision to the complainant, the accused, and potentially others. I mean, you've put all this work into the investigation. It's really important to bring the investigation to a close in the appropriate way and to give closure to the complainant, the accused, and possibly others. So we're going to talk about valuing discipline and or corrective action. I mean, the first consideration have your conduct expectations been violated? And if so, if, for example, if it's your harassment policy, the school has a duty to take appropriate corrective action. What is appropriate corrective action? Well, it's got to be action that would be effective in stopping that conduct from continuing. And it could be different things depending on the situation. Really important to review your employee handbook, for example, if this is an allegation against, if that is the policy that is implicated, to make sure you are complying with any kind of discipline policy that is in your handbook. We update employee handbooks all the time, and I can say there is a very wide range of discipline policies and handbooks, from very bare bones policies that are just general and really give the school a lot of latitude to decide what is appropriate discipline in a particular situation, to extremely detailed discipline policies that have many steps, like, oh, if this is like a first offense, this is what's going to happen. You're going to get a warning, and then you're going to get a written warning, and then maybe you'll be suspended, and maybe your employment will be terminated. And some of them go on for pages. I tend to not recommend having such detailed discipline policies simply because most schools aren't able to comply with them. They're just not practical, and sometimes they forget to even, you know, that they have such a policy. So again, that could give rise to a breach of contract claim anytime a school does not follow one of its policies. And it can also give rise to claims that the school is treating employees in a disparate way that's discriminatory. Really important to consistently enforce the school's written discipline policies to avoid that type of allegation of discrimination. But I would also consider, you know, is this a first time allegation, a finding of misconduct by an employer? Is this part of a pattern? I see sometimes schools deciding on a corrective action that I don't think would be effective in preventing further conduct. So it's really important to consider, is this part of a pattern? And if so, what would be appropriate? In some cases, it may be termination of employment.
I'm just going to add one other thing, which is that it's important to make sure that you follow up at the after the investigation, not only with the complainant, not only we're going to talk about this in just a sec, with the findings of the investigation in general terms, but also down the road, 6 months, a year, 2 years, to check in with the complainant, make sure that the complainant is okay if that person is still employed by your school. That's an important step that gets overlooked. Now, if the allegations are sustained, you're not going to give the report to the complainant. What you're going to do is tell the complainant in very general terms that we've looked into your allegations, we've done an investigation. You might provide a little bit of details on the investigation, like we use so-and-so to investigate and that kind of thing, and that there were sustained findings and appropriate corrective actions will be taken. And that's literally what you say. You don't tell them, you don't go into specifics about what corrective actions will be taken. That's privacy, that violates the privacy rights of the employee who is being disciplined or being given remedial training or whatever the steps there are. But it is important to tell the complainant what happened, either with the outcome of the complaints, either that findings were sustained or that they were not sustained. If there are many different allegations, you may need to tell them, you know, your allegations 1, 3, and 4 were sustained, allegations 2, 5, and 6 were not by the investigator. Now, when you're talking about communicating with the wrongdoer, it's somewhat similar in that you will tell the wrongdoer what happened. Either the alleged wrongdoer is found, and sometimes this can be multiple people, is found to have committed the action, or is found to have not committed or not sustained. If the allegations are sustained, you're probably gonna have to provide more detailed information, particularly if it's gonna result in some type of disciplinary action or termination. And also you're gonna have to have some sort of remedial action. Again, though, you're not giving them the full report, you're just telling them the essence of what the findings were. You want to be careful about telling the wrongdoer everyone who was interviewed because of the threat of retaliation, but that'll depend on the circumstances a little bit. Jim, did you have any other comments on that?
Just a comment. Just wanted to make sure everyone understands, while the investigative report may not be turned over to the parties after the conclusion of the investigation, that does not mean that it won't be discoverable in litigation, right? And the likelihood that it will be turned over to the other side. So it's important to make sure you review it for any sort of cringeworthy comments, commentary, legal conclusions, and things of that nature. So
right. And then I know we're just about out of time here, but just get through these next 2 slides real quick. When you talk about communicating with the school community, schools have often a strong desire. Schools are tight-knit communities to communicate results of investigations to the community. The answer is different to this if you're talking about, for example, a student, some of the student sexual misconduct claims, that can be a little bit different of a situation. When you're talking about the general workplace investigation, typically you're not going to make any statement to the school community overall. If you do, you may want to consider working with a public relations or crisis management firm through your legal counsel to be very careful about what you say so you don't violate anybody's privacy rights. Communicating with your board, another area where the desire to provide the board with information may exceed their right to know or need to know the information. The board has a duty to exercise proper oversight over the school, but you really only want to be providing information on a need-to-know basis. Typically, for workplace investigations, what we see is the board either has a legal committee or an ad hoc committee that they appoint to oversee the investigation, and that is the only entity that's getting any details on the investigation. Another factor there is board members are often parents at the school and know many of the people involved, and that can complicate providing them some of the information from an investigation can complicate or compromise the integrity of the investigation. And then if you are providing these updates to the board, have an attorney there, so it's privileged. Otherwise, in a subsequent lawsuit, they can take a deposition of the board chair and ask what was said about this investigation at the meeting. And that may not be a communication you want to have disclosed. The last slide is just, I'm not going to go through this because we're short on time here, but this is a checklist for a fair investigation. I think it's a good resource material. I don't know if we have any questions. Let me see here. Well, there's just a few questions, so I'm going to try and answer these real quick here. A question about who can be present during the interviews, and I'm going to go to Katie David's question about if the employee has an attorney present, and the school can also have an attorney present. And yes, that's that's correct. And in fact, you can probably have an attorney present even if the employee doesn't have an attorney present. But certainly if an employee or a student is going to come into an interview with an attorney there, you should strongly consider having the school's legal counsel there as well. Can the parent insist they are present during an interview of a student? Generally, from a legal standpoint, no. From a best practices standpoint, as far as managing and running your school, that may be an issue where you don't want to fight the parent, but it depends on the situation. That's one where I would definitely talk to your legal counsel depending on the facts. When presenting evidence to the accused, must you reveal the source? Generally speaking, yes. Particularly if you are going to be taking any type of significant disciplinary action or termination, you are going to need to provide some indication as to the source of the accusations. Otherwise, how can they defend themselves if they don't know who's making the accusations? Now, this is not a universal answer. It depends on the situation. Depends on, I could see a situation involving young children, like where it may not be advisable, or you may want to redact the names or so forth. But in general terms, yes, you would probably need to let them know the source. And there's a question about when do you need to let the wrongdoer know this information? At the conclusion of the investigation. You want to do things timely. You don't want to wait 6 months after it's concluded. You probably want to let the victim know first, or the complainant first, before you let the wrongdoer know. But again, it depends. There's dynamics where you got to be real careful who finds out first, because word may spread even though you tell people not to. And then should interviews be recorded? That is a very, very controversial topic, particularly in the Title IX world. But in general, from a legal standpoint, and Jen, feel free to comment, I think I would always prefer an interview be recorded, always. Because when they're not, there's always disputes about what the person said. And they said, I never said that. And then without a recording, you're stuck. But there is a school of thought that recording causes people to not be as open or candid as they otherwise would be, particularly in sexual misconduct investigations. So there's that school of thought too.
Yeah, Brian, I agree. I think you have to balance sort of, especially when you're talking about issues dealing with sexual misconduct with students and things of that nature, that recorded interview may not be appropriate, even though you may be legally allowed to do it. But yeah, I think as far as preservation of evidence, there's really no better way, and it's better to have the words not left to time and people's memories and things like that. So,
Absolutely.
Right, and with things like, right now we're doing investigations through using Zoom, and Zoom makes it very easy to record, potentially. The one thing I will say on that, if you're going to record, let the person know they're being recorded.
Without question.
That's potentially a felony in California to record someone without their consent about a confidential matter. So
Right.
Be careful about that. Linda, did you have any closing remarks here?
No, thanks everyone for joining us.
All right. Thank you, Jim, for joining us from Maryland. And thank you, everyone. And also, if you have any other questions, I know we kind of ran out of time here, but feel free to email Linda or myself, and we'll see if we can answer them if you have anything else coming out of this presentation.
Yes, thank you, Brian, so much, and Linda and Jim as well. I really appreciate your time and your great presentation here and being a part of our HR workshop today. It's been great. So, and you can also email me too if you have any questions or if you want me to forward them on to the legal team here. I'm happy to do so. And just a reminder, we are recording this session, and it will be available few days after we conclude the HR workshop and conference as well. So thank you so much. And you can go ahead and hop into the next session if you'd like with Paul Butler, Building Financial Intelligence for today's HR leader. Thank you so much.
Thank you very much, Andrea. Appreciate it. Thanks for all your help.
Absolutely. Thank you, everyone.
Take care.